Hi folks, we're Tacitus today, Tacitus Day, your pushback channel, and thank you for joining this audio live stream. Please listen to this presentation as you would a radio broadcast. In this essay, I'd like to talk about the very low bar that activists are required to meet in order to bring an injunction against, in this case, the Trump administration's policies and the executive orders and so on. Now, we see this all over lawfare and legal activism and judicial activism today, that one side only has to meet a very, very low bar of evidence, whereas the other side has to meet a very high bar. And I'll come back to give some examples of that in other courts, but just dealing with this. Now, we recently saw in the media reporting that the Supreme Court had made a midnight ruling to stop the Trump administration from deporting some illegals. I mean, they're illegals, for goodness sakes, from the United States. I think it was a holding facility in Texas somewhere, to deporting them back to, I think it was Venezuela or somewhere in South America. I think it was Venezuela. Now, the material point is here, illegal alien to be deported back to the country of origin. You'd see that as being fairly uncomplicated. That's, well, gee, that sounds pretty straightforward. Are they here illegally? Yes, no one's disputing that. Are they Venezuelan citizens? Yes, no one's disputing that. All right, then we'll deport them back to Venezuela. Oh, no, can't do that. Now, before you get into the technical arguments of it, the Supreme Court of the United States, it's very hard to get them to hear cases. You know, if you remember when the Trump administration in 2020 had some very legitimate concerns about the legality or the illegality of some of the electoral practices used by the Biden people, the Supreme Court wouldn't hear it. They would say, oh, we don't have standing. You have to get a lower court to hear it first, and they wouldn't touch it. And they put what I thought was a very high bar of evidence that the Trump people or the Trump's lawyers needed to meet before the court would hear it. Now, this is a standard tactic, and it goes something like this. Well, we might be prepared to hear this case, Billy Bob. How many witnesses do you have? I've got 10. Well, you see, we need 100 witnesses. No, actually, I do have 100 witnesses. Oh, you got 100 witnesses? Yeah, okay. Actually, we need 200 witnesses. You've got 200? Oh, we need 1,000 witnesses. And they just keep on raising the bar that you have to meet before they'll hear the case. And they just arbitrarily do it. They don't say, well, this is the bar you have to meet. They just arbitrarily do it on the fly. I'm simplifying a little bit, but that's pretty much how it goes. But it also works the other way, that the bar is arbitrarily set very, very low. Now, I've looked at some of on the other side. So I've looked at some of the filings that have recently, since over the last few weeks or the last several weeks, looked at some of the filings. They're online, some of them, you can look at them. And the filings are being made by people called, Lashonda and Shaniqua and that sort of thing. So we can reasonably assume that they're and they're legal aid lawyers. They're from the projects in New York or Chicago. So we're not talking top flight legal minds here. We're not talking about a situation where a particular lawyer who's renowned as a legal scholar, a constitutional legal scholar of the first order, is coming to you with a filing. No, this is not that. This is a legal aid. This is the lowest of the low quality of lawyers in the entire United States. Shaniqua from the projects, who got her affirmative action sociology law degree in Black studies or something, and all she's ever done is be an activist for Black lesbians. That's all she's ever done. And yet somehow not only can she get to file a document with the Supreme Court, but get the Supreme Court out of bed at midnight, or a district court or a appeals court, but the Supreme Court, for goodness sakes, a court that is very choosy over what it touches and hears and listens to. Somehow this Shaniqua can get the Supreme Court, can get the Supreme Court out of bed at midnight to make an emergency ruling. I mean, how do you do that? if some of the finest lawyers in the country representing the Trump administration can't get the Supreme Court out of bed at midnight, but Shaniqua from the projects can. I don't follow that. So anyway, so you have a look at the filings. Now you'd say, okay, well, all right, it may be, Shaniqua or Lashonda or Shalele from the projects. All right, fine. But maybe Shaniqua is one of the great legal minds, constitutional scholar legal minds in the United States. Maybe she's filed a document that's like got a real wow factor about it from a chick that's got an IQ of 10 million. So maybe it's that. I mean, let's cut some slack here and have a look at it. So you have a look at the filing. Again, some of these are online. You can see them. And I'm staggered. I'm not a lawyer or a legal constitutional scholar from the United States. I'm staggered by the low bar of evidence and quality of the filing it's needed. So some of these filings, not every single one, but a decent number of them that can get these emergency hearings are the government may, not will, I've got it in writing, the government may be planning to move some of these illegal aliens that are in the country illegally, who are Venezuelan citizens, may be planning or arranging to send these people back to Venezuela. Maybe. I overheard a conversation by an ICE agent. An ICE agent confidentially said to me that now, if I'm a judge in a superior court or a district court, or now I consider myself to be a serious legal practitioner, a serious jurist, and Lashonda comes to me in her ghetto speak and says that I think I overheard somebody say the government might be planning to. Okay, now assuming Lashonda even gets through to my desk, which would be doubtful if we were talking about serious jurists, but assuming Lashonda even gets the piece of paper through, I'm looking at this. Okay, well, I want to see facts, absolute facts. This idea that you can make a filing saying, I think I overheard an ICE agent saying this, or we think the government might be planning this, or we think the administration might be intending to do so and so, and therefore you have to do an injunction against something that hasn't yet happened for an edict that hasn't yet been declared, to a document that doesn't exist. And I mean, what? You're injuncting against something that could happen, maybe happen, because I overheard Billy Bob say to Jimmy Jack, excuse me, are you kidding me? I mean, that's the standard? That is the fucking standard for getting the Supreme Court out of bed at midnight, or getting a district court or an appeals court? I mean, what? So there's a few things to consider here. Why can't the Trump administration then go to a district court judge saying, well, we think activists may try and impede the progress of this legislation, or may try and prevent this or that. So can you issue an injunction against them before they do anything, because they might do it. They could do it. Well, we overheard some activists saying something, so you have to issue an injunction again. The judge would laugh you out of the courtroom, or laugh you out of his office or chambers. But why is it then that Shaniqua can do that? So I think I overheard an ICE agent say this, you have to issue an injunction against the Trump administrator. Why is it that Shaniqua can write up an injunction and the judge pretty much signs off on the injunction that Shaniqua wrote? And so now Shaniqua may be legal aid one day or the ACLU the next. I mean, it hardly matters. But what we're talking about is very low quality lawyers who have affirmative action degree. I wouldn't call them lawyers. I mean, would you call them even legal clerks or something? But affirmative action, Shaniqua lawyers somehow are able to get access to the most senior courts in the land and get emergency access. Not just I'll file a document and if the judge will get back to me in a few weeks when they can get emergency, so they can file the document on Friday night or last thing Friday. And Saturday they've got, or even Friday night, but certainly Saturday they've got an emergency hearing from the judge. Now, given the amount of documents that comes into a judge's office or any legal practice or that sort of thing, how is it the judge gets to see that? I mean, how many activists are working around the judge? You know, is every assistant that the judge has also an activist? Who's paying for them? Where do they come from? These supposed interns that are working in the judges, where are they from, these interns? Are they actually interns? Or are they themselves employees of NGOs that are activists and so on? So they're making sure that, so it's a prearranged thing that the activist, you know, Shaniqua, the activist, is going to file a document with this judge, and the judges, assistants and helpers, and, you know, the flunkies and all that around the, you know, all the administrative people around the judge, it's already prearranged with them that the judge will get to hear it and get to see it. It'll be treated as an absolute emergency from word one. Again, a prearranged emergency. The judge gets to see it and then immediately calls an emergency hearing within hours or by the next day. I mean, who else gets that sort of treatment? Is that equality before the law? No, it's not. No, it's not. These people are brazenly being given preferential treatment. But again, the reverse is, if you can have the administration's policies stopped or impeded, or you know, have an injunction placed on them or whatever, on the basis, well, I overheard somebody say they might be going to do this, or it's possible they could. If you can have a judge actually acting on zero evidence, again, why can't the reverse be true? Why can't the administration be issuing injunctions against all these NGOs to stop them from filing documents? Well, we've heard this NGO might be trying to impede the thing. I'll put an injunction on them. That'll fucking sort them out. So it's a very much a one-way thing, and this in itself is concerning, but particularly concerning to me is the quality of the evidence, the very low bar. All Shaniqua has to say is she thinks maybe it could be that this or that's going to happen. That's enough to have a blanket injunction produced out of a court. Now, that's not how legal, you know. Now, you know, I've been around the legal and the court system enough, particularly with contract type stuff, to know that if you haven't got the evidence, the judge just won't hear it, won't even listen to it. You can make all the claims you want, but you must have the evidence. And to say that, I overheard Billy Bob say this, and I think they might be doing that, that's not evidence. That's something that wouldn't even see the light of day. But somehow these people with these very low quality filings are able to get direct access to judges, even up to including the Supreme Court, for Christ's sakes. Get direct, then get emergency hearings, and then emergency edicts being issued by the court. Now, why can't everyone get that? Why can only Shaniqua get it based on some hearsay bullshit in a filing she's made? Why? How can that happen? It can't. So it brings into light, in my view at least, how corrupted and subverted the legal system is. And if we're going to have equality before the law, and Shaniqua can just get a blanket injunction made on the basis that she thinks she overheard an ICE agent say this or that, then the reverse must be allowed. That the other side can get an injunction issued against any NGO, but that's not how it goes. It's only one way, and we've got to ask the question: why? Why can Shaniqua make such a low quality filing? How can Shaniqua get her filing in front of the judge within minutes? How can Shaniqua get an emergency hearing within hours? And then how can Shaniqua get an injunction exactly as she wants it, the very next day? These are all serious questions that need to be asked. You've been with Tacitus today, your Pushback channel. Thank you for listening.